General Allen, you have any luck in determining what your situation is? I don't want to take up anything substantive without the public.
I understand.
defender,
She's,
but
the witness on Hansard is not here, Your Honor. I think she got mixed up with Ms. Clack on the other one, so we'll be getting a new date on that one. And we'll wait till,
well, when Mr. Talbot returns, we'll address the issue of the continuance.
thank you. I appreciate that very much.
All right, Mr. Talbot, you want to advise the court what your client's position is?
Yes, sir. We'll proceed with a request for joinder of these counts into one single trial, please.
All right, and let's have Mr. Sheets come around to the podium, please. I'm going to ask you if you, I know you're restricted, but try to raise your right hand to the best of your ability and let us place you under oath. Thank you. Mr. State your full name for the record.
Danny Rohl Sheets Jr.
All right, Mr. Sheets, you're represented by Mr. Talbot of the Public Defender's Office, and the issue that's before the court is whether or not to join two separate indictments alleging that you were guilty of stalking, especially aggravated stalking, on two separate occasions. Your lawyer has asked, and it's a trial strategy kind of a thing, he's asked for the court to join those two for trial. Do you understand that? So that one trial would be held for two separate indictments, treating them as count one and count two. And if we do that, let me explain to you this way to make sure that, have you talked this over with your lawyer?
Yes, sir.
Did you and Mr. Talbot talk about the advantages of doing that versus any kind of disadvantage?
Yes,
Do you
sir.
feel like that you understand what's in your best interest?
Yes, sir.
Do you understand, and I'm stating this on the record, even though I'm sure your lawyer has explained it to you, if we tried those two indictments on separate occasions in front of separate juries, then evidence of one of those alleged instances of stalking might not be admissible in the trial of the other, if you understand correctly. They don't want to convict, the state can't convict you in one case for something that happened in another case under normal circumstances. But if we consolidate those two for trial, then the jury that hears your case is going to hear all of the evidence regarding both of those instances. Do you understand that? Including they'll hear a testimony about count one, if we talk about it being the first date of alleged August the 1st of 2024. But they'll also hear, the same jury will hear the evidence about August the 5th. Now, your lawyer is arguing that those two dates should be considered to be one count rather than two separate counts, and he's made that argument to me, but I am at this point simply saying that that will be a matter for trial rather than for pretrial motions for me to make a determination about what the evidence is or is not at this stage. We haven't heard any evidence. So do you understand everything that you and your lawyer have talked it over? And do you feel like you understand everything that we're talking about?
Yes, sir.
And you understand you are waiving by agreeing to this consolidation of those two counts for trial, those two dates, then you're waiving any issue about whether or not evidence of one should come in the trial of the other count. You understand that?
Yes, sir.
All right. Then I want to show that, I will, for the record, show that the defendant has acknowledged that he is intelligently and knowingly waiving any issue regarding the consolidation, and I will grant the motion to consolidate. These two indictments will be consolidated. The indictment charging August the 1st of 2024 will be count one, and the indictment charging August the 5th will be count two. That would be CR 153 is count one. CR 154 will be considered to be count two of that indictment of a consolidated case. All right. Thank you, Mr. Sheets. You may have a seat. Now, Mr. Talbot, you still have a motion, I believe, for amendment to the indictment. Is that correct?
Sir, and I understand that this is all highly unorthodox. I researched it closely. Is there a cognizable motion to dismiss in a criminal case? I know that these motions are somewhat in the nature of that. In my research, I
If
saw.
you don't raise it, it can't be heard by the court and can't be considered by the Court of Appeals. I have no issue with you making the argument. It
Certainly.
is somewhat unusual in a criminal case, but nonetheless, it's still your duty as your client's attorney to raise every issue that you believe to be relevant and appropriate. So I'm not criticizing you for doing it. I'm just saying
Yes, sir.
it's an interesting theory. So
I didn't take it as criticism. I took it as it is unusual, and I closely researched it, and I saw in, like, for example, treatises like Mark Ward's book, it was described as being uncommon, but has happened before. And so that told me that there was a possibility that these sorts of arguments might be cognizable. But once again, Your Honor, we're at with a motion for asking for the amendment to the indictment to change it from especially aggravated stalking to a different stalking offense is because, again, the nature of the argument is, as a matter of law, the state will not be able to prove a predicate conviction, a prior conviction for which the defendant might be able to be found guilty of especially aggravated stalking as charged in both of these indictments. The reason being, there is no conviction, and there will not be a conviction prior to the August 1 and August 5, 2024 alleged offense dates. That time has passed, and we can't change the past. The state has responded in its response to my motion for bill of particulars, saying that the conviction they allege is a diversion plea that was entered in September 2023, I believe, and that's simply not, as a matter of law, a conviction. And so that's essentially the argument we're making. There's no other conviction on the horizon for Mr. Sheets that would qualify, that would meet that element of the especially aggravated stalking offense. And therefore, it just cannot be especially aggravated stalking. The question that might be before the court is, well, I'll save this, but we say it's not a conviction, and it will not be a conviction. It was a withholding or deferral of prosecution pursuant to a conditional plea, and no judgment of conviction was entered prior to the date of the offenses charged in the indictments.
Danny Rohl Sheets Jr., who had to personally acknowledge whether he wanted two stalking indictments, one from August 1st and another from August 5th, 2024, consolidated into a single trial. According to the defense, the state's reliance on a diversion plea from 2023 didn't cut it. That wasn't a conviction, no judgment had been entered, and legally it couldn't satisfy the element. The lawyer admitted the motion was unorthodox, even citing treatises that described such pretrial challenges as rare, but stressed it was his duty to raise the issue now or lose it on appeal. Judge Wolfe didn't criticize the tactic. In fact, he acknowledged the research and the creativity, but reminded everyone that these kinds of motions edge close to asking the court to dismiss charges before trial. The atmosphere was thoughtful rather than combative, a judge giving space for technical argument, while making sure the defendant personally understood his trial strategy. It was a good example of how pretrial hearings aren't just about scheduling. They can set the whole framework of what a jury eventually hears and what charges even go forward. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.